Hello, welcome to today's Law Awareness Weeks at CDC 2020, The Law and Me Stronger Together, organized by Law Society Pro Bono Services, a collaboration with the 5 community development councils supported by the People's Association, National University of Singapore Faculty of Law, Singapore Management University School of Law, the Singapore University of Social Sciences, and the Singapore Corporate Counsel Association. Some housekeeping before we get started. Relevant materials for today's talk can be downloaded from the handout section, which you can see on your screen. If you're using a mobile phone or tablet, the icons will appear on the top right-hand corner. If you're using a computer, you should see the icons on the right. Feel free to ask any question during the webinar. Just use the questions pane on the right of your screen as well. Your questions will only be seen by the organizer, and we will do our best to address them in the course of the talk or at the end of the talk during the Q&A session. Now, please also note that this discussion and any material provided in this webinar is not intended to substitute professional legal advice. Do consult a lawyer if you require professional legal advice. Now, today's topic is divorce and you. And my name is Leanne, your host. And I would like to introduce our panel of experts today. They are here to share with you their expertise and answer whatever questions you may have. Our legal expert is Ms. Susan Tate, founder and director of OTP Law Corporation. Susan is a litigation, Susan started her legal career in 1989 as a litigation lawyer. However, in recent years, she would much rather be known as an advocate of the peace approach to resolving disputes. Just 2 years into her own practice, or rather 2 years into practicing in a law firm, Susan started her own practice, now known as OTP Law Corporation. She is also a mediator, a mediation advocate, a parenting coordinator, and a collaborative family lawyer. And we are also very fortunate to have with us Ms. Abigail Lee, founder and executive director of Healing Heart Center. Abigail brings to the panel 15 years of experience as a professional counselor with a focus on children and adolescents. Abigail is fluent in English and Mandarin, as well as some dialects. She is currently the president of Association for Play Therapy Singapore. Susan and Abigail, thank you very much for joining us this evening.
Thank you, Leanne. Yeah, very happy to be here.
That's terrific. Okay, I think let's dive into our topic for today. I think divorce is a difficult topic to talk about, but it is a topic that we must address. In 2019 alone, there were over 7,000 divorces in Singapore, and that works out to about 3 for every 10 marriages, I think. I believe that many of our participants come today with questions relating to divorce, and I encourage you to send them in as soon as possible using the questions pane so that we can try to answer them as we go along. Now, let's start with what a person must prove in order to get the court to grant a divorce in Singapore. The Women's Charter sets out the law in Singapore concerning civil marriages. I believe it provides one ground for divorce, but it lists 5 factors which satisfy this ground for divorce. Does that mean to obtain a divorce in Singapore, Susan, the applicant must satisfy at least one of these 5 factors?
Yes, Leanne. So maybe I just give a bit more background and a bit more detail. There is really only one ground for divorce, and that is if your marriage has irretrievably broken down. How to prove irretrievable breakdown of the marriage? You need to satisfy these 5 factors, okay? 1, if the other party has committed adultery and you cannot live with him or her because of the adultery. Unreasonable behavior, such that you find it intolerable to live with him or her. Desertion. So desertion means the other party left the house for 2 years. Okay. 3-year separation, but the other party must consent to the divorce, or 4-year separation. Then you don't need consent. So these are the 5 factors. And in Singapore, there are a few criteria, but yes, you must prove that your case falls within these 5 factors.
Okay, so in the case of someone who, I suppose maybe feels that they satisfy more than one of the 5, does it matter which one they use to file for divorce?
Okay, so that's it's actually a more complex question than you can imagine, Leanne. Let me just start with the most uncontroversial. All right, 3-year separation, and if the other party consent. So usually this kind of cases, the court only wants to know, why did you separate? Okay, so you need to give some details. Now, as you can see from the first 3 factors that I just mentioned, which is the adultery, intolerable behavior, as well as desertion, you know, these are factors which you need to elaborate and possibly highlight certain bad behavior of the other spouse. So they can get quite, you know, when you see a particulars like this served on you when they file the divorce, it generally generate very negative feelings. So depending on depending on the person, sometimes you might just want to, if of course your case satisfy that ground. Some people separate because they found out that the other party has an affair, and then they separate for 3 years. So do you want to go on grounds of adultery, or do you want to go on 3-year separation? Some people, most of the time for adultery, right, you can twin it with unreasonable behavior. So I often do that. But for adultery,
sorry, please.
For adultery, you need to name the third party sometimes. So that's also an additional criteria that you have to meet.
Okay.
Yeah, so depending on whether you can meet those criteria, you might want to decide which factor you want to rely on.
I've heard or encountered some people who seem to have the impression that the choice of the factor that they will use to apply for the marriage, if they can somehow show that the spouse is a wrongdoer, meaning if they can use adultery, if they can use unreasonable behavior, they seem to be of the impression that it means that they will get more when it comes to division of matrimonial assets, you know, stuff like that. Is that the correct impression?
Very, very common perception. Okay, I get that all the time. You tend to think that, oh, if I can blame the other party, then the court will be sympathetic towards me, and I will be able to get more or get care and control of the kids, you know, get a bigger share of the house. I will go into some detail about the process, because it makes sense actually only if I tell you. In Singapore, the process is divided into 2 stages, but I will get into that later on. Okay? The short answer is, it is not, very often it is not going to affect the ancillary matters. What are ancillary matters? They are like things relating to children, things relating to assets, things relating to maintenance. Okay, especially behavior relating to adultery. Yeah, but some of these particulars for intolerable behavior actually relate to things like, well, this person never paid, my spouse never paid maintenance. Okay, most of the contribution towards the family is by me. So those kind of particulars will be relevant for the factors when we consider who contributed more towards the matrimonial asset. And then, you know, so those are things, it's very complex actually to explain like this. But yeah, just a simple answer is, don't think it is related, and therefore don't try to bring up all the bad behavior just so you think it can influence your matrimonial assets or maintenance, or that you are going to get the kids.
I think would it be fair to say, basically, unless the bad behavior is something related to monetary reasons, in the sense that maybe it's not taking care of the children financially, stuff like that, then maybe it might apply, because division of matrimonial assets is a monetary issue, right?
Yes.
So like you were saying, I think a lot of our participants might feel that adultery is the worst sort of, or the best form of attack. Like, you know, you're very upset with your spouse, and you have evidence of that. You kind of assume that that means when it comes to division, you actually will get more. But in fact, that is the very one that is irrelevant.
Correct.
right?
Absolutely spot on. Yeah.
Okay,
I just want to also add that if you go on the ground of adultery, like people ask me, I mean, if I want to go on adultery, a lot of it is emotional because most grief, I think, when it comes to, this is from my experience, is when you find out that you have been betrayed with your spouse committing adultery. So sometimes you feel like you really need to use the ground of adultery because it's somehow it managed to vent something. Okay, and the other practical thing is also if you have engaged a private investigator to trail your spouse, and that investigator has found out facts relating to this adultery, you can also claim the investigator's cost when you go on the ground of adultery. So that is a very big difference between, say, going on adultery and going on other grounds.
Right.
Okay. Yeah.
Abigail, any thoughts on, you know, if you've counseled someone perhaps who is in a situation like that, meaning they discovered that their spouse has been unfaithful to them, do you feel like there's a sort of emotionally a big difference, say, for example, compared to someone who perhaps is on the verge of divorce, but for other reasons?
I think many times, and Susan, thanks for that. It was very helpful because I think even from my end, when I see spouses who come and then, you know, the reason or the ground for divorce is adultery, I think what Susan has brought up is that it's really not such a straightforward scenario. You know, there's a lot of complexity and a lot of details that need to go in. And on my hand, many times when I see the spouses, and they come at different portions, they come where it could be at the initial stages where they just discovered and divorce proceeding is taking place versus it's been going on for so many years. Marriage has broken down, it's irretrievable. So hence this is the way. So a mix of emotions, I would say, you know, anywhere from shock, denial to betrayal to deep hurt to anger to, you know, so a mixed ball of that. And I think before any, in a sense, rational decision can be made, it's really my role is really to help unpack through some of these emotions and thoughts. What's kind of happening, what's the impact of that, and how also does it even impact functionality at work or even raising up the kids. So going to the kids and smiling at the kids when you are having to deal with all these emotions, it's really not easy and it's not simple.
Yes, yeah, I believe so. Okay, interestingly, before I was going to move on to divorce proceedings, but a question has come in from a participant about one of the grounds for divorce. So let's deal with that first. And the question is, for separation, Susan, do the husband and wife need to stay in separate households?
Okay, so legal definition of household, it may be a little bit different from what our audience understand it. Separation can be, of course, physical separation. You can leave the house, and so that's very clear-cut separation. But if you live in the same house, okay, you live under the same roof, but in fact, you live a life that is quite separate from each other. So we always liken it to a tenant. Imagine if you are a tenant in this house, and then your spouse is the other tenant. I'm talking about like not good friends kind of tenant, okay? It's just normal tenant relationship. And you don't do anything for each other. You don't wash clothes for each other, cook for each other, things like that. That is what we regard as separate households. Okay, and then you can still go on the ground of separation. I have many cases, right, where two parties over the years, they as good as, you know, live two separate households, but they talk to each other only about the children. Okay, the court will accept that this is separation. Now I want to give a disclaimer. Separation cannot be just two people, don't talk to each other, then we separate. No. There must be something that happened, and there must be a consciousness by both parties that the marriage is over. And hopefully you communicate this to the other party. Okay, meaning actually I don't think this is working out. I want out. Okay, this marriage is not working out. But in the meantime, you stay in this room, I stay in this room, and then both of you didn't go and do your, get your divorce done. So that's what must happen. Not just physical separation, as in like living in two households, but you must communicate the intention to separate.
Or that the marriage is come to an end.
Yes, correct.
Okay. We have quite a lot to cover, so I'm going to attempt to answer this one other question about adultery. And Susan, if you could help me to confirm it. So this participant has asked, if a spouse discovers the other spouse has an affair, does that mean that the wronged spouse can file for divorce immediately, or must there be a period of separation? And my view is that no separation is required if the intention is to go on the basis of the adultery lah. Am I right to say that?
Correct.
Okay.
Lian,
So,
hang on. Just a small thing, because I don't know whether the audience know that in Singapore, before you can start a divorce, you must have been married for 3 years first. Okay,
that's
guys.
Right.
So you must have been married for 3 years. So if you get married already, in the first year you discovered that your spouse has committed adultery, I'm sorry, but you still cannot start the divorce because your marriage is not 3 years. Okay, so I hope that is a simple answer.
Yeah, that's part of the eligibility criteria, I believe, right?
Correct.
Okay, so let's quickly, this part I think we've briefly touched on, and we probably will revisit it when we come to ancillary matters. Let's quickly run through divorce proceedings in the Singapore courts. As you mentioned earlier, Susan, our family justice courts, which hears exclusively family law matters, basically divorce is run like a two-stage process. So maybe we can quickly, sort of guide our audience through how that works.
Yeah. So every time my client comes and see me for the first time, right, I'll go to the whiteboard and I'll draw for them. Okay, so I don't have a whiteboard today, but everybody please, put on your imagination hat. There are two stages, okay, in Singapore divorce proceedings. Stage A deals with the breakdown of the marriage, right? So if I'm to draw a picture for stage A, it will be the picture, a stick lady and a stick man. Very simple. The court only wants to know, okay, did you satisfy the 5 factors? Is there divorce to be granted? After stage A is what we call an interim judgment. So as the word suggests, it's interim only, it's not final. Then you move to stage B, okay? Now what the stage B deals with, I actually touched on that just now, is ancillary matters. Ancillary means anything that's ancillary to the marriage. Largely, if I'm to draw a picture again, I will draw a small stick person, okay, maybe 2 if you have more than 1 children, more than 1 child, and then a house, money. Okay, yeah. So this all move to stage B. Now in Singapore, you technically cannot start stage B until stage A is over. Okay, if you go to court, you litigate it, you fight this, you must finish stage A first. But in practice, that's not how it is. Very often, the 2 stages are fused because of this big thing called mediation and counseling. All right, I don't know whether we should talk about this now because it can get very confusing. But if I'm to just explain stage A and stage B, perhaps that should be it for now, because later on I will talk a bit more about mediation and counseling with Abigail, of course. Yeah.
Actually, now is a good time because I think we can move on just nice. Yeah, because I understand that for court proceedings, at some point quite early on, assuming for our participants' benefit, let's say if I go to court and I want to file a divorce, is it before I file the writ, which is I think the first court document, they will tell me I have to go for mandatory counseling, is something like that, right? So maybe we can, since that's the way it works in court, maybe we can explain to participants how that works. Yeah.
Hang on, I hijack a little bit first, Abby, before I pass the baton to you.
I heard the word counseling, I want to jump in already,
Yeah. Okay, so yes, so as I was explaining, right, to be honest, I think a lot of what we say today you might not be able to remember. But before anybody can start to file divorce proceedings, they must attend compulsory parenting program counseling if you have a child or children that's under the age of 21. Okay, so that is a must. That's step number one. Abby, after I pass it to you, you can explain a little bit about this MPP, Mandatory Parenting Program Counseling. Okay, then the second thing is after you start the divorce proceedings, okay, the court will also make compulsory a mediation session for anybody with children. It's compulsory. Yes. So that is the part where I say sometimes stage A fused with stage B. Because if you're contesting the divorce, let's say you're contesting stage A, lawyers can push for this mediation to happen quite quickly to see if parties can resolve both some of stage A and children's issues at the mediation. Often, counseling is also involved. Again, compulsory, even after the writ. So there's 2 counseling sessions, at least 2, okay, that a party must attend. Okay, to you, Abby, to continue.
Well, the mandatory parenting program is basically a 2-hour program, and it's run by the divorce specialists, support specialist agencies, what we call DSSAs, right, who handles this. And basically the 2-hour program, what we look at are just basically 4 objectives, right? So one, financial challenges of divorce, what that entails, how that looks like, how divorce will actually impact living arrangements, how are things going to look like now, child custody and access, which is really important, and also the importance of co-parenting and having a parenting plan. So it really something, even though it's kind of like just 2 hours, but I think for a lot of people who might think about starting divorce proceeding, but maybe not having an understanding or maybe having thought through some of these, great opportunity to at least start thinking through about some of these things and consider what might be some of the details that they probably might need to look at. And I think it's many times I think it's a lot more than people anticipate. I think sometimes people feel that, okay, I just go through the divorce proceeding, I apply, that's it, everything goes smoothly, everybody agree. Unfortunately, many times it's not so, because there's, other than the physical aspects, administration, all the documentation, there's also a lot of emotional pieces that come along with it. And that is sometimes, to me, I feel that the parts and the components that's very difficult to decipher. And when that gets thrown into the mix of wanting to achieve an agreement of sorts, that can be very challenging.
Yeah. And I have actually personally met some people who have been through the counseling session, and even if they decided subsequently, it didn't actually change their mind about getting the divorce. It was, like you said, very helpful in setting them on the right path, to think about how they should settle some of the matters or start thinking about some of the issues that they will eventually have to deal with when they start the application, right? Now, but I know that one common concern that people have is especially when one spouse doesn't want to get the divorce, and therefore obviously is not going to attend this counseling because they refuse right? They don't feel that there's anything wrong with the marriage. Then the husband will say, what counseling? Why should I go for counseling? So there have been situations where the spouse who wants to start divorce proceeding worries that because the other spouse refuses to attend counseling, then they cannot commence the writ. Is that what happens, Susan?
No. Okay, so it's very clear. Only, okay, you don't necessarily always have to go counseling. So there are 2 situations you don't need to go counseling. One, if both parties already agreed on what to do with the children. So you've already got that in writing, okay? That means you've already sorted it all out. Number 2, if you are the defendant, meaning you're not the person starting the divorce. Okay, now there's one proviso here. Even if you're a defendant, if you want to start a counter claim, meaning you don't agree with your spouse ground for divorce, or sorry, factor for divorce, and you also want to counter sue. Now, if you want a counter claim, you also must attend the counseling. So it's the proactive person who needs to attend the counselling, not the spouse on the receiving end.
Okay.
Yeah.
Okay. That's interesting. But on that note though, let's say we move back to, since we are on this slide, right? Back to counseling, Abigail. If one spouse doesn't want to attend, whether it's a court mandated counseling or even let's say let's say I decide that I'll give it a shot. I want my spouse and I go for counseling because I'm contemplating. I feel I can't stand it anymore. I want to go and get a divorce. And I say, I give you one final chance, but my spouse still refuses to come. So in a scenario like that, is there any point in me coming for counseling on my own?
I think let me just kind of unpack it and divide it, differentiating between mandated versus voluntary. Because I think mandated, should either spouse decide not to attend, even though it's mandated, I think there is a separate consideration for that. Yeah. But where it's voluntary, and I always explain to couples this way, there is what I call a within and a between, and the within are issues or concerns or challenges that perhaps we experience on our own, and then we bring it into the between, which is the dynamics that take place in the marriage. So under certain circumstances where one spouse may not be open or may not be willing, and this is something I hear very common. Oh, my spouse is the one that's the problem, so my spouse is really the one who should be attending counseling. But a marriage, it really takes two people to work. So on that note, what I would really highly encourage is take that step, and almost like I take it as that humility step. Take that step first and attend counseling for yourself. Explore your own issues and what you bring to your side of the marriage. And is there things that perhaps you can work on? Are there things that perhaps that can be communicated differently? And what I have seen many times when that happens is the other spouse, and in fact, I have this couple years and years and years, 30 over years they've been fighting. But the amazing thing is they're still together, all right? And one spouse actually decided she wanted to come for counseling. Husband wasn't keen. But what happened was, and I spent about a year and a half with this particular spouse. She worked on herself, she worked on her blind spots, and I think we all have blind spots that have contributed negatively to a marriage. And as she worked on that, husband saw the change in her. And then husband said, hey, I think I also want to go and pay a visit to your counselor, and work a bit on myself. So at that moment, we decided, okay, they will each have individual sessions first, work on their issues, and then come together as a couple to work on the between. Because by then, they would have that awareness of actually what was happening for me personally was also the stuff that I have brought into the marriage that has affected the marriage negatively. So not easy work, but they took that step and they made the effort to actually do it. And marriage is still intact, and they are still just, I wouldn't say that it's a perfect marriage, but they are more aware of what they bring, and they are able to communicate, and they are able to push through some of these concerns. So
that's very heartening.
Yeah.
Although I think there's no perfect marriage.
No, I wish there is,
I doubt it now. Yeah. Okay.
Well, the one who brings in the perfect piece, but
Yes, that's true. Okay, before we move on, I just want to acknowledge some of our participants' questions. I know there are a few more questions relating to adultery and all that, but I think we have quite a lot to cover. So we try to come back to that at the end of our talk, okay? So stay with us. Meanwhile, right, let's consider this interesting scenario. Now, the background of this is I want to talk about divorce proceedings and how that can be a very stressful process for the applicant or, both sides lah. So let's imagine this scenario. We just call it the difficult defendant. And I believe it is a scenario that many who have commenced divorce proceedings before or know of someone who've done that against an unwilling spouse, they will be familiar with this, right? So let's just imagine Sue files for divorce on the basis of unreasonable behavior. Her husband, John, doesn't want to divorce. So he threatens to make this whole process as difficult for her as he can. He decides he's going to contest the divorce. He counterclaims against Sue, and he tries ways and means to delay the proceedings. Maybe he applies for adjournments, he files many interim applications, or maybe amends his statement, stuff like that. And meanwhile, on a side topic, he produces his income tax statement to show the court that he has no income. So he then tells Judge, Your Honor, I cannot pay. And this one is actually a real life story. But Sue is in this rut because she knows that his income comes in the form of cash. Maybe he's a private tutor. Then the parents just pay cash, right? So as a result of this, Sue's legal cost keeps escalating. And she now feels very, very stressed. She's very worried. So in this kind of situation, first of all, is this a fair representation of what a difficult divorce can be? We just try to deal with the worst case scenario, basically. And if so, what can be done in situations like these, Susan?
Okay, very, very common, but yet maybe some things I would perhaps not so what a difficult defendant will do, but anyway, difficult is as difficult comes. They will try to do a lot of things to block. Okay. Firstly, a person who doesn't want a divorce, unlikely he will counterclaim, because to counterclaim it means you also want a divorce. So you probably put in a defense and you contest. All right. Now we talk about escalating legal costs first. Escalating legal costs happens both sides, unless the difficult defendant is representing himself. So he doesn't have to pay a lawyer, right? Yeah. Now, so that's one scenario. But each time, let's say I'm representing a client and against a difficult defendant, but each time I succeed in any application, John will have to pay legal costs. All right. So despite the fact that he's not represented, if he loses, he still have to pay legal costs. That's one thing. Okay. All right. Secondly, now if he wins, he doesn't get legal costs because he's not represented, right? He doesn't have to pay any lawyers. So this is the legal cost aspect of the game. But divorce proceedings, if you go to a senior and experienced lawyer, can be prohibitive, can be expensive, very expensive. So how do we manage this? The key word is the peace approach. Okay, what the peace approach is really about, see if parties can not engage with the litigation process and worked out through negotiations, mediations, maybe even counseling, right? What the parties really want. Sometimes a difficult defendant is not just being difficult. There is something that he is trying to stop. Okay, just because one party says it's time for me to get a divorce doesn't mean the other party is ready. Okay, I have a client who didn't want a divorce, but the husband started the divorce after 20 years of being very unhappy in the marriage. She became the difficult dependent. Through one session where we talked to each other, me, the other party's lawyer, the other party, and my client, we decided that we should hold the divorce off for 1 year. So the agreement was for the husband, stop this divorce first, then start again in 1 year, where she confirmed in writing she will not block. So these are some of the things that can solve the issues without us having to go to court. Because trust me, if you go to court, you can't get this kind of solution. Yeah. This kind of solution is only possible if you mediate or you negotiate directly. Okay, so that's why I really love the peace approach.
Yeah, that's very unique. I got to say, and it's a solution that's quite unusual.
Correct.
Agreed not to. She just needed that extra year for personal reasons.
Correct. Correct. Yeah, there's so many reasons, right, underlying why this and that. I have a client who separated from her husband for 16 years and never. Yeah, I only took out divorce after 16 years. So many
Yeah.
underlying reasons that a lawyer or a judge cannot begin to fathom.
Yeah.
Okay. Now, in Singapore, it's very common that maintenance payments are very lacking, sometimes very slow from husbands, or, generally there is a feeling, right, that I'm the one earning all the money. Now that you want a divorce, why should I pay maintenance and things like that? But clients must understand that maintenance paying is an obligation, especially to children. Okay, so the court has made it very, very simple for parties to claim maintenance. So you think that you can, and many cases, both parties are not represented by lawyers, so they keep their legal costs very low. And it's very easy to do it now. Go and claim it yourself. Yeah.
Okay. So on this topic of the difficult defendant, here is a question that I think it is just a pretty straightforward answer. This participant wants to know, my husband doesn't want to attend, he doesn't want a divorce, and he refuses to attend, he says he's not going to go to court. Okay, he's not going to attend any proceedings, he's just going to ignore whatever's been served on him. And this person wants to know, can I still get a divorce without his attendance? I think the simple answer is probably yes, right?
Yes, definitely. So I have many cases where the defendant don't want to engage. So he never attends, he doesn't file anything, but it's just a matter of time. Maybe it is not straightforward as if you both agree to a divorce and agree to all the terms. Those are like super fast, what I call a McDonald's divorce. Don't mind me using this word. Okay, it's like eating fast food. You go there, you pay over the counter, it's easy, fast, cheap. Okay, so that's the divorce. But if the other party doesn't want to engage, eventually you still get the divorce. In fact, it will still probably not be as cheap or as fast or as easy, but it's still much better than, say, a difficult defendant, meaning somebody who is always going to court to oppose this and that.
Right, right. Okay, so since we're talking about it will be, quite a lot less or more affordable than if you had to deal with a difficult defendant. Let's answer this question one of the participants has raised. How much does a divorce cost? I'm afraid this question won't be so straightforward. Susan, you may want to try.
I just want to spread the good news that it should get cheaper. Okay, I think the family justice courts as well as the government, there is a very serious beat. Actually, over the years, they have tried to make divorce process simpler and simpler. All right, so, and as practitioners like me who advocate the peace approach, we also want to try and keep the costs down. I will tell you, very, very few of my cases are very litigious, very few. Most of them are settled, and then the fees are much lower. But you're dealing with somebody as experienced as me, so my rates will be high because, But if you go to a younger lawyer or somebody who may not charge so much, the legal process, maybe, I don't know, Law Sought Pro Bono Office is also starting something, a program where they are going to bring the cost down. So maybe somewhere between, if it's completely uncontested, it should be between 2,000 plus. That should be the starting point. I know there are people who charge $600. And I don't go through divorce with them. I don't have them as my lawyer. I don't know what their level of service is. But I can imagine if you are charging $600, you probably need a lot of your cases to make ends meet, I suspect. So you probably don't have that much time to devote on one client.
Yeah,
So
and I think and it's also a bit difficult, to address this member of the audience, right? Like you say, it's hard. It's like any service that's being provided. I think in Singapore we don't have this regulations that fix costs. If I'm not wrong, right? There is no such thing. It's not like you walk into the clinic Then some specialist clinics, it's fixed, right? $45 for first consultation, repeat consultation, how much? That they have that. But I think for lawyers, we don't have. So if your question is there, some kind of a guidance that is fixed? Not really. It is merely a service, and therefore different lawyers, different different qualifications, different expertise, a level of experience, like you've just mentioned, Susan. I mean, if you're going to see a lawyer that's been doing it for 30 years, then of course you expect to pay more for the experience that they bring to the table and the advice that they can give. Yeah.
I want to add something also. Most people, actually divorce is top 3 traumatic events for a person, any person, okay? And so the whole divorce process is not as easy as you think. It's not like buying a house, all right? Maybe people think, buy a house, everything is standard. Divorce is not standard. Don't even begin to imagine it can be standard, okay? So what you're dealing with, even as you say, okay, me and my spouse, we will agree on everything, we'll make it very, very amicable. But what you don't understand is that what you think is okay may not be so okay. I give you an example. I have 2 children, let's say, okay, 1 child, 1 son and 1 daughter. We decide, we agree. Son goes with you, daughter comes with me. The truth is, yeah, so I agree, but actually the court will frown upon such an arrangement because separating the siblings will not be good for the kids. Yeah, so this is just one example, all right, that you should always try and get legal advice. That's one. And I just want to touch back on why I think counseling and all that is also very important. Very recently, I saw a client who just found out that her spouse has been having an affair. From my experience, I could tell that this person is very, very distraught. Okay, and he's in one of the beginning stages of the 4 stages of emotion. There was a lot of denial, and then sometimes he slipped into anger. And the truth is, when I ask him questions, I know that at that point of time, the decisions he made will not be good because he's filled with all this emotion. So if you go to an experienced lawyer, even this kind of things can be identified. And the lawyer, a responsible lawyer, will tell you, don't do anything now. Okay, so it's not just go to court, I fill in some forms and then we get divorced. Really, it's not quite like that. Understand that it's so traumatic as you're going through it, and it can be very, very difficult.
Yeah. I don't know if it's fair to ask, but Abigail, a practical question, right? Before we move to ancillary matters. I'm guessing that one counseling session, let's a scenario of that Susan has just raised, someone who is very distraught. So then he comes out, lawyer says, oh, don't file now, you're in a very bad state. Practically speaking, how many sessions do you think? Obviously, I know it's different for every individual, but maybe based on the number of people that you've met and helped, how many sessions do you think someone needs to go through before maybe they can sort of calm down a bit and, be better able to process the things that they need to process for divorce application?
I think it really, really depends, Leanne, because I think apart from, let's say, using Susan's example, right? Apart from just that one single incident of, of experiencing that high stress intensity, whatever previous negative experiences that the person has experienced, either individually or within the marriage, we don't know, is a question mark. So all that actually adds on, and it can actually accumulate, and it can actually trigger the person, including with this recent incident. So coming into counseling, they are carrying all these years, anywhere from like one time off incident to years and years of emotions and thoughts and all these things all jumbled up together. So definitely, I think upfront, one counseling session, unless somebody out there has a magic wand that I do not know of, which they will need to recommend to me, rarely would I say like one counseling session would be able to just fix it. I would say, and I would probably be very cautious because even in counseling, nothing is a guarantee. So for people who guarantee 100%, I might caution against that. And the reason why I also say that it depends, because when we experience something, and this is not just individuals who are experiencing divorce or trauma, but even for us, when we are high stress, our emotional brain kicks in. So it's about that fight, flight, freeze. I don't know what to do. I just need to know that I have to survive. So our thinking brain, our decision making, our executive functioning part of the brain is not functioning very well at that time. So even if I can make decisions on that spot, you may not have that clarity to be able to cover all grounds or a lot of grounds. So in counseling, I always tell my clients, slow it down, because they can range anywhere from being in shock and they cannot even verbalize anything to they just and then they just talk and talk and talk and talk and talk and talk and talk. So on both extremes, it's like, okay, no, just slow it down. Let's calm the body, calm the emotions, soothe yourself down first. And I think even before the decision, it's okay, what else is happening in your life that we need to ensure stability and functionality? Because when you are undergoing through high stress, some of us, we have to work. Some of us, we have to continue looking after the kids. Some of us have elderly parents that we still have to attend to. There's a lot of things that still has to go on. It doesn't stop just because you are undergoing through this current situation or this experience. So we need to ensure that there is that stability that is also happening for the individual, that the person can actually function. Then, okay, let's look at how can we make decision making a lot clearer so that we can facilitate a better outcome, regardless of which pathway the person ultimately makes. And I think at the end of the day, at least they would have known that, okay, I've covered sufficient ground, and I know that this decision that I'm making, I'm not being coerced, or I've really thought it through and through. Yeah, so I think that's true. Important. And so definitely not one or two session. And also practically, they come to me, I'm seeing them for the first time, I'm meeting them for the first time. I don't know much about their background, what they have experienced, how did they get to where they are. So it's really hearing about what was the scenario and the situation that has led to them being the situation that they are in now. So a lot of that takes place in the initial stages of counseling.
I think it's important to understand that when you choose this path, what you're seeking is, like you said, some form of emotional, if not healing, then at least calming down. So I think if people do come for counseling, then they have to be prepared that this is a process that takes time. Yeah, and it's also not like shopping, right?
Yeah, and also sometimes after the counseling session, they're like, okay, I'm calmed down, I feel better. And then they walk out, and then like a few hours later, they are like, cannot. I suddenly had this memory, I had this flashback, I had this trigger again, or I saw
probably
my spouse and everything else comes up.
I was going to say WhatsApp is probably the biggest trigger.
Yes. So
yeah, it's difficult. Okay, that's true. Okay, let's quickly, because I think we have quite a lot of questions that we want to deal with at the end. I just summarized, we are moving into ancillary matters. And earlier, Susan, you already mentioned ancillary matters is stage B of proceedings. It's after interim judgment, and it will cover your child, which is the care and custody issue. It covers maintenance and division of matrimonial assets. So this will be part 2 of the things that the court will deal with when interim judgment for the divorce has been given, right? So let's jump into it and start with the most difficult one of all. Let's talk about children. Maybe we can discuss the court's approach when it comes to how we should handle children in the case of a divorce. Susan, would you like to start?
To be honest, I think the best way to handle children issues is through the peace approach, nothing else. Okay. However, maybe I talk about the law first, all right? There's only one thing that the court is interested in when it comes to dealing with issues of children: best interest of the child. That's the one big consideration. But what is best interest of the child? Okay. So through the years, the court has already devised a whole system where they think, okay, what is good for the child will be certain factors. All right. I can't possibly tell you everything because there's so many things, but maybe I can address some of the myths All right, what is not necessarily true? Okay, number one, just because you are the spouse who doesn't work, therefore you don't have the money. It's not true that the other spouse who has the money will get care and control of the child. Okay, so that's one big thing, because a lot of people think, oh yeah, I'm not the one working and therefore I will lose the child. Okay, so who is the constant caregiver? Who is the primary caregiver? That's what the court wants to know. Because the big factor is, don't try to disrupt as little as possible the child's life. Okay, so I will just talk generally like this, because I see a lot of questions which when I answer, I think it will be more to the point.
Yeah.
Okay, so best interest of the child and some of the myths that has to be corrected. All right, now I also want to define custody, care and control, and access, because these are the most common questions. Okay, they're apart from maintenance for the children, which is another huge topic. Just know that maintenance of the children is about money for them, and both parents who are working, both also must pay. Okay, a simple answer is usually they look at the income and then they proportion the expenses from the income, reasonable expenses. Okay, you cannot just say, oh, tomorrow I want to give him even more tuition. No, it's the current expenses. So that's maintenance. Okay, now custody, care and control, access. In Singapore, there is a difference between custody and care and control. All right, it doesn't happen in every country, but in Singapore it happens. Almost always is joint custody. Custody deals with important and significant decisions like school, religion, surname, big decisions. Okay? Now then there's care and control. Care and control is about daily caregiving of the child. Who does the child stay with, mother or father? Okay? So this one, the caregiving parent or the parent with care and control will make certain daily decisions. What to eat for breakfast, what time I bring to school, blah, blah, blah. Okay. Now, the spouse or the parent who does not have care and control will have access. Access will be things like, okay, when can I see the kids? How long can he stay with me? Things like that. In Singapore, used to be, well, you can say, I don't want to give overnight access because the child is not used to, the father doesn't know how to take care of the kids. Now, unless there are issues that will endanger the children, overnight access is almost a given. Okay, then there's overseas access. The audience may not know, in Singapore, 1 in 3 marriages deal with one spouse who is not a Singapore citizen. There is one foreigner, 1 in 3 marriages. So you will have
a higher
lot of,
percentage than I imagine.
it is. I was told that 4 out of 7 children have at least one parent who is not local, as in not a Singapore citizen. Yeah, that is the kind of percentages we are looking at, is very, very high. So issues like overseas, sometimes relocation, you know, I'm a spouse who came from US and then now I want to go back because the marriage is breaking up. These are very, very common issues. Okay, yeah, but anyway, so access is about this. When do I see it? My personal philosophy is, nowadays this generation of parents are quite different from, say, my dad's generation, where it's very clear the breadwinner and then the caregiving. Okay, the dads are very, very involved nowadays. So more and more people are asking for shared care and control. They will share care and control, not just one parent have care and control, the other parent have access. So this is the broad thing about children.
Okay, so while we are on this topic, let's answer one question here. Somebody asked, how do I gain access to my kids if my spouse is not allowing me access and I don't know my kids' whereabouts?
Oh dear.
Yeah.
It is very, very sad. I actually had a case. It's like this, okay? Actually, one of the most traumatic things of, apart from the discovery of adultery, is the taking away the children. Okay, so I often advise my client who say, I really need to leave the house. I want to just leave and take the children. I always say, no, think carefully first. It's not like this. You shouldn't do it this way, because sometimes you escalate it to a point where there's no return, you know. The other spouse will completely feel very betrayed, and then you cannot talk anymore. Everything is litigated. But anyway, I had a case like this. What happened was the person decided to engage a private investigator to find out where the children are. Of course, it can be a bit expensive, but some of the things you need to do, so that's one way, okay? But the other thing is this, almost always the judge will grant you access, almost always. So if there is no access, sorry, and the guy is, the person, the other parent is not cooperative, take out a court application. Take out a court application.
Push it a bit and ask, right, what can the court do? The court doesn't know where my children are, what?
Yeah, but the court will definitely summon the spouse. So I mean, unless she's telling me, I completely don't even know where my spouse is. It happens, for example, if the spouse, one of the parent left the country. You marry somebody from another country, and one day this person just disappear and you don't know where he is now or in which country now. That is a child abduction case. It's parental child abduction. Okay, it's very complex. I don't know whether today I can talk about this, all right? But if the parents, both parents are still in Singapore, take out a court application. There must be some way you find where your spouse is, where the other parent is. Either you know where she works or he works, okay? Or you know, there must be a way.
And I think this answers one of our participants' question, because I believe it's a lady, because she says, I want to divorce my husband, but he doesn't want to sign. And I cannot live under the same roof with him because I think he's not a positive influence on my children. And she wanted to know if she, who is a foreigner, wants to return to her own country, can take her kids out. So I think we've answered that. Don't do that. It's extremely traumatic, I suppose, both for the children as well as for the spouse that's left behind. And
Yeah,
Yes.
and also just add on, many times I also hear parents, saying that, yeah, they're so young, the kids are so young, they're not going to remember when they grow up, and that is a big myth, because children, although young, they may not be able to verbalize their experience, but the memory system, is such that they will be able to remember, even if it's not visually, somatically, there are a lot of research that they do remember. So, it's always to caution and to really think twice about such actions of just removing kids, just like that.
Yeah. And also, yeah, please, Susan.
Sorry, Liana. I want to put on my parenting coordinator hat also to talk about this. Okay, it's interesting that this parent thinks the father has a maybe not a positive effect on the kids, okay, or influence, right? The truth is this, and after having dealt with cases like this for 30 over years, I have had the privilege or honor of going through some cases where when the parent come to me and start a divorce, they are babies, but now they are full-grown adults. So I have seen the transformation. Yes, I have. And I want to just caution everybody that you do not want to do something where it's going to impact upon the children so badly that the problems you will have is not going to come from your other parent. It's going to come from your kids. And these kids will have problems in school. They will have problems with relationships. They will have problems with you, because there's some kind of blaming that will go on, all right? And essentially, they are very, very unhappy people. So these are very important things you want to think about for what you may regard as intolerable situation now, but please think a bit further and don't do anything. Yeah.
That's very, very wise. Anything to add, Abigail? Because I was also thinking this is a good time to, for whatever reason, the child always seems to be, even with the most well-meaning parent, I think in the moment of anger or frustration, or when you've decided you want to break the marriage up, for some reason, I find like it's very hard for even sensible persons to avoid influencing their children. you know,
Mhm.
especially for those who feel that, oh, what my child says in court is going to affect access, custody, or can control. So I
Right.
don't know, maybe you have something to say to parents who feel that perhaps out of fear of losing their children,
Mhm.
they feel this need to manipulate them or to maybe
Yeah.
poison their minds against, you know, the father or the mother,
Mhm.
something like
Mhm.
that.
Yeah. And I think,
Yeah.
when Susan brought up just now about how the court really looks at the best interest of the child, it's really the best interest of the child, but not what you think is the best interest of the child. So again, many parents, I will hear them say, yeah, I know what's best, is my child. But
Mm,
yet at the same time, you are providing, and I have no qualms believing that yes, you do have the best interest of your child. However, at the same time, the other spouse, you may not like them very much, and they probably are not going to be your best friend, but the other parent is still your child's parent, and that doesn't change just because a divorce or separation takes place. And
mm,
something that I do get the parents to actually share about is, can you name just one positive thing about this other person sitting across the room from you? Now, they probably won't say that best husband, best wife, but many of them will actually say that, okay, actually, at least he cares for the kids. At least
mm,
he nurtures. So, on that note, it shows to me that both mother and father have strengths, have qualities and skills that are able to input into the best interest of the child together. So then we advocate teamwork. Okay, you don't have to be
mm,
each other's best friend, but how do you then work together as a team so that it also doesn't cause your child to be caught in a loyalty bind? And what I mean by that is that
exactly.
because as children, many times, and again, it's a lot about brain development and child development as well. We are very concrete thinkers. We haven't moved into abstract thinking, especially for children at a young age. So, in the mind of a child, if one person is bad, that means the other one is good. So, if parents keep reinforcing that, the child is going to grow up thinking one is good and one is bad. And imagine when the child grows up and they are able to have abstract thinking, a bit like what Susan was mentioning about seeing them from young to old, and they realize that, oh no, there's actually this other facet that has never been told to me that I have never actually considered. It's
Mm,
gonna turn against the parent that they thought was good all along and realize, oh no, I've not been given the full picture. And I think
yeah.
we really do a very great injustice for the kids and for them emotionally, because imagine, and research shows, and these are kids who many of them grow up and then they might end up having a fear of intimacy, not wanting to get married. And I think
Mm,
one thing that parents need to ask is that what we want for our kids?
yeah.
Yeah. So the
Yeah.
emotional health and the well-being of our kids, not just
Yeah.
now, but for when they become adults.
Very true. Yeah. I think the long-term view is very important when it comes to children. Yeah.
Mm-hmm.
And to put aside your immediate feelings and, yeah, because it's a very long journey for the child who has to live with things that they didn't choose, right?
Mm-hmm. Mm-hmm.
Okay, let's quickly, there is this question about therapeutic justice that I want to deal with at the very end. We've had one or two questions about that. But let's quickly finish with our ancillary matters. Children being the big topic that I think is probably, on everyone's minds. Let's also quickly talk about maintenance. Earlier, Susan, we had this scenario, right? Where this guy tells the judge, see, I have no income, this is my IRA statement. So coincidentally, someone did ask the question, if my spouse is not working, then does he have to pay maintenance? So maintenance seems to be
Okay.
quite, yeah, I think like you said also, a lot of people do try to avoid having to pay maintenance or pay as little as possible. So how does that work?
Okay. Do you know that even a bankrupt will be ordered to pay maintenance for his kids?
Wow.
Yeah. So I want to just divide into two groups of people. Okay. One group, genuinely no job. COVID has struck and they really have no job. But I also want to speak from, I'm talking about maintenance for children first. I also want to speak from, say, a parent who is a good parent. Almost always, this parent will find the way to maintain the kids. All right, yeah. So almost always. So that kind of parent, if they lose their job, somehow they will still find money to feed the kid. Then there's this other group that says, I will quit my job just so I don't pay maintenance. I will make myself a bankrupt so I don't pay maintenance. I'm sorry, the law will still hold you liable to pay maintenance. If you quit your job, what the court looks at is, okay, your qualification, what did you work before? Okay, what kind of money were you taking home? And then they will just infer that, okay, it's easy for you to do this again. And I know you don't have a job now, but you're still obliged to pay maintenance based on what I think you should be paid.
Oh.
Okay, so yeah, it's not so simple like, oh, I got no job, I don't want to pay. No, not quite like that. Maintenance for children, I've already explained, usually based on income. If one parent earns 1,000, the other parent earns 2,000, then you divide the expenses by 3, and then that's a very simple way of calculating. But we also have a lot of other factors. What if my child is special needs child, need more money? Because special needs, one of us cannot work because I have to take care of the child, right? Yeah. So things like that, it's a lot of things, but today I don't think we have time to go into all the nitty-gritty. Okay?
Yes. Yeah.
Maintenance for the
one quick
wife.
question.
Yeah,
Before
sure.
we do maintenance for the wife, I think the reality that I have often encountered is that because one spouse has not been paying maintenance, so we're not talking about court application, but the reality is that, let's say, parties been in an unhappy marriage for a while. One spouse is irresponsible, always disappearing, and then never gives maintenance and etc. But the other spouse is a working mom. So she is able, at great cost to herself, obviously, maybe take on an extra job or something, because it didn't occur to her to, oh, my husband's not paying that, I run to court, right? So the poor mom takes on an extra job, and in a way, she alone is able, and I say able because it's a great deal of burden on her, to maintain the child. So in that scenario, let's say this goes on for 1 year. So the husband hasn't been paying anything. So can't an argument be made that, well, you have been successfully maintaining your child on your own income, so then nothing lah.
Can. I mean, they will always say that lah, The law is such that both parents are obliged to maintain the kids, right? So you have to maintain the children. You have very, very good reasons why you can't. For example, I'm the mother and I really cannot work because I need to take care of 3 very, very small kids. Then of course that's a fantastic reason, right? Yeah. But otherwise, sorry, you still have to maintain. And in fact, it's this kind of situations where I really feel for the mother. They have to take on 2 jobs, 3 jobs, and actually they're too busy to go down to court. That's why the court proceedings are now much easier. And do you know, you just log in and you can already submit a claim. Go to the IFAM portal. The whole system is being revamped so that some of these very common applications are getting easier and easier. So you can log on, you can make your claims, submit your documents, and the court will decide. Okay, so the father will have to go to court, or the other parent will have to go to court to explain why you don't pay maintenance. So it's getting easier and easier, so don't give up. Yeah, don't give up. Yeah.
All right, so back to spousal maintenance.
Okay, where was I? Yeah. So in Singapore, a lot of men feel that it's so unfair, right? That men has to pay women maintenance and not the other way around. But of course, the law has changed to allow for claims by husbands against wife, but only if you are so incapacitated that you cannot work. Okay, so you have to have some kind of disability that you cannot work. So those situations are very, very rare. And wife no longer automatically get maintenance. More and more women are working and they are successful, sometimes even quite often actually, they get paid more than the husbands. So court is now very keen not to award maintenance. $1 maintenance also is not automatic anymore. for very rich husbands and wives, okay, when the court orders a very big proportion of the matrimonial assets to the wife, those situations also the court may say no maintenance for wife because I already give you so much of the matrimonial assets.
Mm.
So for husbands, you can cheer up a bit. It's not so easy
sounds
now.
like times are
For one.
changing slightly.
It is changing, and it should actually, yeah.
Yes, I agree. Okay, so one last simple question about maintenance from a participant before we move on. What's the difference between asking for no maintenance order for the child and a nominal maintenance order? Actually, why would someone ask for no maintenance for the child? But okay, that's the question. No maintenance versus nominal maintenance.
For
Is
the
there a
child?
consequence? Yes.
No. There is a consequence if you ask for no maintenance for the wife. Because after that, she can never ask for maintenance again. But there is no consequence if it's for a child.
Ah, okay. Which means that it can later be changed if circumstances such that suddenly you need more. Okay. Okay.
And
That's
Correct.
it's not for the rest of the life of the child either, right? Is there like an age cut
Well,
off when you stop?
Okay. Unless there is a special situation, for example, a special needs child, okay, who always constantly will need a lot of care. Once you turn adult and finish your education, and by education, I think, first degree, because some people just keep going, yeah, you can stop after that. But otherwise, you have to keep maintaining your kid.
I see. Okay. Okay, so let's move on to division of matrimonial assets. Quickly, maybe we can just, I think actually, I'm sure, it's pretty straightforward in Singapore, but this one would be one of the more contested issues in an unhappy divorce, right? So some tips about division or some things you want to mention about division of matrimonial assets, Susan? Maybe I think some people have misconception, right, about what it is and what is not covered.
Okay. First, we decide what can be considered as matrimonial assets. Okay. One big rule: anything that you buy during marriage, okay, anything is matrimonial asset. Of course, I'm not talking about small items like your underwear and all that. Okay. I'm talking about big items. For example, a house, a car, even some jewelry, things like that. Anything that is acquired during marriage is matrimonial assets. And acquired means one of the spouse use money to buy, right? What is not matrimonial assets will be assets that you bought before marriage, and it is not used by the family, or it is not improved by any one spouse. Okay? There is a very subtle difference between assets acquired before marriage and inheritance and gifts. I have very rich parents. They give me a house. All right, and then the whole family stay in there. Is that matrimonial asset? If it is inheritance or gifts, and it is used by the family or improved by both spouses or one of the other spouse, then it is matrimonial asset. I know I'm sounding very confusing, okay? Because why the difference? But generally, there are exceptions to inheritance. There are exceptions to assets that you acquire before marriage. They can still become matrimonial assets if some factors are satisfied. Do I answer the questions more or less?
Yeah, I think so. But okay, so what about how is that divided? It used to, remember earlier when we were talking about adultery, people feel that if I can prove that my spouse is the adulterer, he's the wrongdoer, or he's the one who is guilty of unreasonable behavior, then I will get more. And then there are other people who say it's 50-50, regardless, of length of marriage. So I think, what about that aspect? How is the division done?
Okay, there's really no simple answer, but I'll try to simplify as much as possible. Okay, what do the courts look at when they decide how to divide matrimonial asset? One word: contributions. Okay, just contribution. There is direct contribution, there are indirect contributions. Direct contributions, very simple. Who paid for this? You bought a house, this house cost 500,000, who paid towards the 500,000? That's direct contribution. Then we have situations whereby one party was not working or is not working because she's a housewife, right? The court will look at indirect contribution. Okay, me being the mother, being the wife, over the last 30 years, blah, 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 right? Things like that. So they look at this kind of contributions. Why is long marriages relevant? Well, the case law is such that for long marriages where one party is working and the other party is not, the court is inclined to award equal division. Equal can range from 50-50, 60-40. Okay, towards equal, right? So there are cases, quite a lot of cases where they say 50-50. There are a lot of cases that also says 60-40. There are so many factors that goes towards contribution. I don't have the time to talk about them all.
Yes.
Yeah, but this is the big picture.
Yeah. Okay.
Right.
Okay. I think there have been many interesting, we've very broadly touched on division of matrimonial assets. Maybe one very quick last point before we move on. For maybe many participants, HDB flat is a concern. So is it a must sell? If if that's the only asset that you have, then how? Then what's going to happen if the parties don't want to live together and they just have the one HDB flat?
Simple answer: one party buys over, the other party share. Okay, so you don't have to sell it. You can do that, but you still need to satisfy the nucleus factor. You have to have a family nucleus before you can buy over. So if the kids are with you, then you have that family nucleus. Okay, the HDB is I have cases where they are quite relaxed, but very, very rare. Certain executive flats where they don't allow like just a single person to buy over. So you need to still satisfy their criteria. Yes, but you can buy over. Yeah.
Are there situations where people, because HDB flat, for example, in the present economic crisis, would have fallen significantly in value? So in that scenario, do people are they forced to hold back on their divorce because, what they're going to do if they sell, they worry that they don't have enough to, say, for instance, cover their CPF or whatever loans they might have taken out?
So usually not both parties want the same thing. One party may want to sell desperately because he's moved on or she's moved on and needs the money in the CPF, even if it's discounted. One party may say, no, I want to wait for the right price. So quite often a timeline is given. Have to sell within 6 months, 9 months, whatever. Yeah. So, it's not always that both parties also agree. To be honest, if both parties agree, no problem. You can agree to sell later when the price is right, but you must sell. Yeah.
Okay, since we've covered all the three ancillary matters and we do have quite a number of questions from participants, let's try to answer as many as we can with the remaining time that we have. A quick one, this is interesting. This person said, can you share more about long divorce proceedings or rather how long divorce proceedings can take? Because we earlier talked about the monetary costs, but we didn't provide sort of a timeline about how long I would reckon uncontested and contested divorces typically take.
Okay. I always tell my client, if you engage in the simplified divorce process, simplified divorce means you agree on everything and then you just file the papers together with a draft consent order. The whole process can take 4 to 5 months, depending on how quick you sign all the things and file all the papers. Okay.
But that's quickest already, lah. That's
quickest. Okay, maybe 4 months, quick, very quick. Yeah. Why? Because from interim judgment to final judgment, definitely 3 months you need to wait. Okay, so if it's Speedy Gonzalez and you do everything very quickly, you still take about 1 month. But the negotiation period towards all the terms agreed, a sensible one set aside about 2 months, because people change their mind or go through a lot of things. So, you know, and then they negotiate. So that takes a while. So those are for short and easy and divorce proceedings. How long is my longest? 5 to 7 years, but that was a long time ago.
Wow.
It doesn't happen like this anymore. Yes, it really happened
even
like
for
that.
complicated ones.
Yes,
Nowadays,
even for complex. Maybe about 2 years, and already it's quite hellish. Okay, don't forget, this is just the basic first level proceedings. If there are appeals, then it can go on and on. Yeah. Cost, easily 6 figures if it's very contested. Easy. Yeah. That if not 5 figures, right? So that's the kind of cost and the length.
Okay. I think this one is a question. Let's talk about it, and maybe Abigail, you can chip in as well. It says here, could you share a bit more on implications for divorce cases where there is family violence or child abuse? Will that impact the care and control, access of children, division of assets, and all that? So I think this person is asking about family violence situation, but in a divorce context.
Wow.
So if, I don't know at which point in your divorce application would you reveal that there's family violence?
I chime in first lah. Okay, yeah, it is actually very relevant. It's a good question. Family violence is often cited as unreasonable behavior particulars. Okay, definitely, if there's child abuse, it will definitely impact upon care and control. Sometimes when the child abuse is very bad, it can also impact on custody and access. Okay, so custody, you can even apply for sole custody. Access, if you have been violent before, unlikely you can have unsupervised access. You need supervised access. Okay, so that can be done at DSSA, where somebody else is there to watch over you when you're having access to your kids. So it definitely will impact. Does it impact matrimonial assets? You remember if I say the court looks at contributions. So they will look at who contributed directly and indirect contribution. So if he is a neglectful parent or he or she, then yes, that goes towards contribution.
Okay.
Yeah.
Okay.
And I would just say that if there are reasons for concerns of family violence or child abuse, so for family violence, do check with the family justice courts, because there are procedures in place about protection orders. And, you know, with child abuse, with the MSF Child Protection Unit services, that they will be able to advise that a lot better.
And I would also, agree. And I would add to participants who are interested or who have questions related to family violence. We recently, as part of Law Awareness CDC this year, also did a talk just on family violence. So send an email perhaps to the Law Society Pro Bono office so that you can find out more about that talk. I think materials can be made available to you. Yeah. Right. So moving on, this question appeared a few times. It's actually also new to me. Somebody has asked, we've seen the court moving towards therapeutic justice. So what exactly is this therapeutic justice that we're talking about? And, you know, I don't know whether it's just a case of, like you say, shortening timeframes, or does it encompass more? Susan?
It's a very special topic for me because it's very close to my heart. Therapeutic justice is something very, very new. It's even new for family lawyers. Okay, it's only May this year that the presiding judge of the Family Justice Court say, okay, we want to administer therapeutic justice in our family justice courts. It's a concept that was invented in the US in the 90s. Okay, and they started that actually for criminal proceedings. Really, the focus is on healing parties, not on legal rights. That means you don't go there to court and say, oh, she didn't contribute to the family because of this and this and this adulterous affair, blah, blah, blah. But it's more on trying to mend relationships and see whether parties can move forward on a journey that is going to make them repair or still preserve that bond somehow. Okay, very, very critical for issues relating to children. Ask me exactly how it's going to be done. To be honest, it hasn't started yet, and all of us are still not quite clear. But I am very, very sure that mediation and counseling will be a big feature. They will be big, big features for therapeutic justice administration. They are even suggesting that before you go and start a divorce proceedings, they will want what they call a pre-writ mediation. That means parties come together first, see whether you can work out all your differences and your issues and all that, talk it out and go for simplified divorce. So they want to make it like, okay, you must do this first, then you can start the divorce proceedings. So there's a lot of talk now, a lot of revamp to make it such that, yeah, it is going to be very interesting, very, very interesting.
And as it
I
is,
like it
even
very much.
Yeah, already we are seeing quite a lot of change in terms of how easy it is to get maintenance and how the courts are, and focusing on no fault issues when it comes to ancillary matters, separating the two. So it will be interesting to see how we take that even further.
Yes.
Yeah.
But for some of us in private practice, we are already doing some kind of practicing this kind of TJ. So in short, it's called TJ, where we want to advocate peace approach. So we come up with a program that you can encourage parties to sit together, but you get the experts' advice. That means you don't just negotiate over the kitchen table. It's not quite so simple, like I mentioned earlier. You get the experts to come in. You still save a lot of money, and you definitely save a lot of angst. Okay, and then we navigate with you, teach you how to resolve this. Counseling sessions may happen over a period of time, but almost all the mediations that I've conducted is completed in one day. Imagine all that process you can reduce to one day and then be done with it. That is something should be very attractive.
Yes, and it goes to show, I think, the importance of having the objective third party present. I think the thing with mediation, it probably helps with this couple going through crazy emotional roller coaster, right?
Yes.
Okay, one last question before I have to wrap up, I've been told. Okay, so this lady says, I have been married for 30 years, separated for 10 years, but still under the same roof. We are planning to start divorce proceedings because the children are now above 21. Do we still have to attend counseling sessions, or can we just start with our respective lawyers?
Yeah. You don't need to go for counseling if none of your kids are below 21.
So they can just
voluntary counseling.
Yes, which probably will then save time when it comes to all the nitty-gritty, like division and maintenance and all that, right? Yeah. Okay, that's great to know. So we have to bring our Q&A session to a close, I'm afraid. Please don't forget to download the useful resources regarding some of the stuff we've discussed today. They can be found in the handouts pane on your screen. We hope you found our webinar today on divorce useful. Your feedback will help us make future webinars more relevant to you. So once you leave today, you will receive a survey, and we really appreciate your feedback on today's session. Susan and Abigail, thank you so much for spending time with us this evening. Before I sign off, this might be of interest to some of you. As you can see on your screen, there is a QR code that says CovAid. Visit CovAid at worldwideweb.nus-covaid.com. It's a wonderful website created by a group of law students at NUS, National University of Singapore, who saw the need to support the community. And what they've done is they've set out to explain all the COVID-19 laws and the budgetary measures as simply and clearly as they can for the benefit of everyone in the community. So do use this website and spread the word. With that, on behalf of Law Society Pro Bono Services, as well as our wonderful panelists today, thank you for joining us. Have a great week and stay safe.
Thank you, everyone. Bye.